Hi everyone, this week we're looking at theory as a component of research. And this is an interesting week in which I hope to dispel some misconceptions around the idea of theory and the use of theory. And some of the misconceptions, of course, comes from, I suppose, the common sense idea that theory and practice are different things. And people talk about that all the time, this is a theoretical approach or this is a practical approach. And I think that's something that has a bad influence on legal researchers, because it implies that there is a distinction, that you either work in theory or you work in practice. And for a long time, as you'll see in the readings this week, law has been very resistant to theory. And in fact, we sort of end up corralling theory into one subject, quite often jurisprudence or legal theory. And that also, the fact that it's corralled in one area, I think also reinforces that assumption that it is somehow separate from or different from practice. So we'll start with the proposition that all practice is based on theory. And when you think about other fields, say science or medicine, of course that makes sense. You're not going to build a rocket without understanding anything about gravity. And I think that's a solid observation in law as well. You're not going to understand how a system of law operates or how it should operate without understanding some of those core concepts around, there's the basics we come back to all the time in terms of rights theory, in terms of rule of law, in terms of the idea of how law is supposed to operate. We see it very clearly in the topic for this year when we have the pressure to have more and more efficient, expedient and cheap committals processes on the one hand, and on the other hand we have the question of, well, how do we preserve our rights systems? Now, without any concept of theory, then we don't have any foundation to fall back on when we talk about the rights system, or we evaluate the rights system and its value against those commercial and practical considerations. And the temptation then would be to say, well, we're being practical here, we shouldn't recognise rights because, we can't cost them, we can't put a price on them, and we're being practical. So there is, even in rejecting theory, there is often a theory behind it. In being apparently apolitical, there is a certain amount of politics that informs that and informs the rejection of theory. Because theory is, if nothing else, it's a tool. And it's a tool for you to critique and analyse proposals or the status quo or whatever. And I think that's one of the reasons why it's so important for law, and one of the reasons it's important for us to talk about in the context of research. So I always like to think of theory as a toolbox with lots of different tools in it, lots of different options, and you can take each of them out. You can have a go with your particular problem, your problem topic with each of the theories, and see if those theories help you. Now, there are some theories that will help really, in some situations, that won't necessarily help so much in others. And in the notes for this week, I outline a few of the major theories. Now, I don't think many of you will have studied jurisprudence yet. You may have. But these are a bit of a preview of the basic themes out of jurisprudence as well, and to give you just an idea of what those things are. So the sort of things you should have touched on in Intro to Law, but that's a long time ago. I know I keep saying that. There's a lot of stuff that we cover in legal research that are things that you have covered previously in Intro, but there's been a lot of water under the bridge since you studied it, and it's worth returning to those things. But, anytime we're talking about rights, for instance, then you need to go back to rights theory, and you need to be able to find someone who explains or talks about what rights actually are before you can actually talk about what rights are. Because if you just end up with the rights as they are written, or the rights under the Constitution, which are not very many and not very well described, then you end up in a situation where you're not doing that perspective justice, and you're not actually able to express what those rights are. So for any particular topic, one of the key ways to crack it open, if you're not sure about what you're doing, is take one of those theories and apply it to the problem. and you'll get a different sort of analysis of the problem and a different take on the problem depending on what you do. So if you look at committals from the idea of rights theory, or if you look at it from the perspective of feminist theory, or you look at it in terms of legal realism, you're going to get very different perspectives. So there is advantages of using multiple perspectives, and in fact, one core template that you can use when writing essays is, here are two theoretical perspectives on a topic. Which is the one that's the most persuasive? But sometimes you don't even need to go that far. Sometimes just having a particular argument and then you use the theory as a structure. I talk about it being a backbone in the study guide, and it's part of that core structure of any sort of argument that you apply to any particular topic. So it has a beginning and an end, and you can see all the way through you're arguing this sequence of things. And where you embed the theory, some is where you provide the evidence and the rationale for your position. You've got two options, you choose A or B. I've chosen A. And why do you choose A? Well, sometimes you can choose it on the basis of data, and we're going to talk about data next week. We've got some statistical data that proves A is the best option. Sometimes you use a precedent. We've talked about precedent and legislation in the previous weeks, and sometimes you use theory and you say A is the better option because this is the theory we've adopted, and this theory clearly explains why that's a better option. So the message really is don't be afraid of theory, and also don't see theory as something that is abstract or different or out there. Another analogy you can talk about is, there's mechanics and there's engineers, and mechanics that fix things and they're more practical, and engineers design things and they're more theoretical in what they do. But you need both of them, and they both need to have the same set of skills. A mechanic without any engineering skills, even learned engineering skills, doesn't know what they're doing. They're just following rote. They're not a very good mechanic. An engineer without mechanical skills doesn't know the context in what they do. So some people are going to be more theoretical, some people are going to be more practical, but everyone needs a bit of both. All right. And you may hear the term critical analysis a lot, particularly in comments you get back on papers, and theory really is one of the fundamental ways in which you create and demonstrate critical analysis. You're able to use the theory to crack open the problem and analyse it, and the theory gives you those tools to do it. So you're not just trying to argue like people argue on the internet, where you say, oh well, this is my opinion because I reckon. You're able to say, well, if we look at Rawls' theory of rights, then this is what happens to this topic. If we use Rawls' theory of rights to examine the committals process, then this will provide this sort of analysis of the proposed changes. Right, there are two readings this week, and they're both talking about what theory means for legal researchers, and they're both quite good. Otherwise, I wouldn't have set them, obviously. And the first one, by Dagan and Kreitner, look at some of the different ways in which law uses theory, because law has this tradition, strangely enough, of being a very sort of anti-academic discipline until relatively recently. Originally, lawyers didn't have university degrees. It was all done through an apprenticeship style system. And when the law qualification moved into the university, some of that baggage came with it. And some of it also came through with, legal educators, and it was passed on from educator to educator. And you end up with, occasionally, this idea that, it's all about black letter law is somehow superior because, it's not abstract, it's concrete, and it's dealing with those practicalities. Black letter law is extremely theoretical. It's based on its own assumptions. But if you're sitting within that bubble where all you see is black letter law, you think what you're doing is natural and obvious, and everyone else is doing something strange. So Dagan and Kreitner look at things like law and policy, socio-historical analysis law, and an interesting one that I'll leave you to read about, the idea of law as craft. So they provide a number of different options by which we can look at what the existing work is around law and theory and legal research and understand it in a theoretical framework, even though some of the proponents and some of those researchers might say, we're doing black letter law, we're not doing theory. The other articles by Burns and Hutchinson, and we've seen Terry Hutchinson previously in the term, and they're looking at the shortfall of skills in using data, which is the topic for next week in legal research. So it's a bit of a transition piece that bridges this week and next week. But they also look at the importance of theory as the foundation of that analysis, that it's not enough to be able to say lawyers need to be more data literate, they need to be able to read a spreadsheet, they need to be able to portray data in a visualized sense, in a diagram or a chart or whatever. We need to be able to do those things, but we also need to be able to do that in a way that's informed by theory, and we understand what we're doing from a theoretical behaviour, a theoretical background. And they also talk about some of the things I talked about earlier, where law was a very much closed shop, closed system. A lot of the legal educators, in the first phase, were people who didn't have university degrees, or if they did, they had it in divinity studies or something that was not in law. And law built itself up as a discipline in a way that was in many ways sort of defensive, and was many ways had a bit of a chip on its shoulder and a bit of low self-esteem towards the other sort of, long-running schools of thought, like economics or history or whatever. So there was a great deal of, well, we're law, we do things differently, that really doesn't wash anymore in the modern collaborative environment. And what Burns and Hutchinson also point out is that as legal careers change, the basics and having people who are intellectually agile around theory becomes very important, because we are seeing, and since they published that article, we're seeing rapid change and development about what legal careers are about. And once upon a time, a long time ago, probably even before I graduated, you could say, well, I've graduated from law now, I have all my skills, and all I'm going to do from now on in my professional life is one thing. But increasingly, people are being told, well, your job now involves economic analysis. Your career now involves problem analysis or systems thinking, or any number of different disciplines, culture change. So, and this is really something that's appearing most readily in the big firms. In those big firms where you've got lawyers and accountants and people who are developing specialities that are no longer being I'm a taxation law specialist. Their specialities in things in terms of conflict resolution and problem solving, and other interdisciplinary analysis. So what that article tells us is, where that change is rapid, it's important to equip students with the ability to adapt rapidly, because the kind of law that's out there now, and the kind of legal practice that's out there now, is not going to take you through the rest of your professional life like it once did for law graduates. It's changing very, very quickly, and no one seems to know where it's going. There's some interesting forecasts as to where it's going, but that's a topic for a different area. And in some ways, when you're in that period of great contrast and change, some solid theory is a bit of an anchor, and it's a bit of reassurance that if you've got your basics of rule of law, rights theory, etc., legal positivism, you know the intellectual rock on which you're building, then if you suddenly are in a position where you have to figure out culture change around regulatory structures, then you can think in those terms, and you can rely on that solid knowledge and solid theory that you have. All right, other things. This week, when we talk about navigating the law, we look at databases. We'll have a little bit of a look at the library databases. The CQU library's done a kind of an odd thing. and they've provided almost a Google-like search interface on the library search, and they sort of de-emphasize the databases that articles exist in. And this is a little bit problematic because it can then become very difficult for students to understand the way that this knowledge is stored and paid for, and the fact that there are a great number of different academic databases that store different journal articles, and the universities buy subscriptions to some of these, and you need to be able to search for the ones that we have subscriptions for, so you can access that information without having to pay for it. And that's why occasionally students will say to me, "Oh, I just find everything on Google." Well, sometimes you can, and sometimes you can find repositories of articles that are sitting in sort of the grey market, where the authors have put them on ResearchGate or one of the other systems, where the law or the intellectual property law about what they're doing is a little bit unclear. But ultimately, most of the output of the academic world, and this is, data and theory and combinations of both, are owned by corporations. And this is deeply unsatisfying for a number of academics and a number of just members of society. When most of this research is paid for by public money, and academics are required to publish it in a journal that then, and the academics do all the work writing it. They don't get paid for it. They do the editing. They don't get paid for it. And somehow the big corporations like Elsevier manage to sell it back to us. And there's historical reasons for why that happened, but they're not good ones. So again, I mean, if you're growing up with this, with the internet as commonplace and with this as new, you possibly don't even realise using the library search engine that you're actually searching these paid-for subscription-based databases. And why not do it while you can? But occasionally you will hit something, and they'll say, "Oh no, we don't have that journal," and it'll flip over to the page for the journal where they'll say, "We want $50 for you to get a copy of that article." So unless you understand that there's this set number of articles and that set number of databases, and the library only buys subscriptions to some of them, then a lot of that won't really make sense to you. And it's kind of nonsensical and kind of mad as it is that we've gotten to this point. And I know there's been some certain people who have occasionally argued that things like cancer research should not be locked behind a paywall. That should be available to everyone. But, of course, the corporations who are making money out of this don't agree. And, the chairman of Elsevier is regularly giving himself $5 million Christmas presents for a job well done by selling material that was created by people who gave it to the corporation for no money. And some journals, particularly in the sciences, people pay to have their work published. So it's even worse. You're not only donating your content to the publishers, but you're paying them to publish it, and then they're charging everyone else to access it. So I think I'm hoping that world will change somewhat before too long, and there are enough people that it's not just a few radical rabble-rousers at the edges who are angry at the system, that it's the anger at the journal system and the publishing system has become very much mainstream, and something may happen. But unfortunately, in the meantime, for people who are researchers at the start of their career and who are working in a university that is, not a very rich university and can't afford a lot of the subscriptions, it does limit sometimes what your options are. All right, and the workshop this week is looking at a literature review. You're not going to do a full literature review, you're not going to have time to do that. But we look at the format of what a literature review is, which is basically a formal way of keeping notes on what you've read. And we look at sort of the way in which you write it and how you keep notes around a literature review, and some of the literature management software that's available now that can help you along that process. And we'll look at EndNote and things like that as well. So we'll introduce you to some of those ideas and why it's important to make sure that you have a system by which you keep knowledge. If you're writing a 4-page paper, a 2,000-word paper, you can probably keep most of that in your head as you go. Maybe not. But you can start keeping that in your head. But when you start working on bigger projects, and particularly projects where you're sharing the work with others, that's when it becomes very important to have a very strong system that you can go, okay, I know I've read that book, I've read that article, I've read that chapter, and I've kept those notes in a very formal way that I can access them 6 months later, that I can hand them over to someone else on the team to look at and review and add their comments to as well. So a literature review is the sort of the basic concept here, but we're going to expand on that more in this week's workshop.